presenter for this morning is with two of them. It's a joint paper by Ms. G.A. Chaturi Sajeevi and Dr. Mahanamahewa. So I think you will be making Ms. Sajeevi will be making the presentation on behalf of both of them. It's on comparative analysis of directors' duty of care, skill and diligence in Sri Lanka, Australia and UK. Floor to you.
Good morning, the chairperson, Mr. Vijaymanna, distinguished ladies and gentlemen. So the topic of my presentation is a comparative analysis of directors' duty of care, skill and diligence in Sri Lanka, Australia and UK. Right. Now, as you all know, Companies Act number 7 of 2007 in Sri Lanka made considerable changes to numerous areas in corporate law, including the codification of the common law duties of directors, which are provided from section 187 onwards. Now, the objective of codifying these common law duties was basically to make the duties of directors certain, consistent, comprehensible and accessible. Now, section 189 of the Companies Act codify the common law duty of care, skill and diligence that you can find through numerous case law. However, the statutory duty of standard of care that you find in section 189 has not yet been interpreted in a court of law. So the exact scope and the dimensions of the duty are vague. So in this paper, our objective is to, first of all, to summarize what is the common law duty of skill and care and how it has developed over case law, and to see how similar statutory provisions have been interpreted in other jurisdictions, and to see also how far we can adopt those interpretations and the developments in other countries to this country. Right. What knows he of England, who only England knows, says Rudyard Kipling. And also there's a very interesting quotation from during influence of development of comparative law, where he says, "You are a fool if you do not buy or borrow from another person's garden a vegetable which does not grow in your own garden." So the study adopts a qualitative approach using comparative study design. For the purpose of comparison, we have taken Australia and UK as other jurisdictions. This study is primarily a library-based study where the material used in the study include legislation, judicial decisions, books, electronic and internet sources, and journal articles. If you look at section 529 of the Companies Act, which defines a director, it includes any person occupying the position of director, which means the Companies Act tries to bring a wide group of persons within this definition, including what you will see is there is no demarcation between executive and non-executive directors or independent directors. And also shadow directors are brought within the definition of a director in the Companies Act. Now, looking at the provisions of the Companies Act, one can see that there must be at least one director in every company, unless it's a public company where there's a compulsory requirement of 2 directors. And the Companies Act, through statutory provisions, give all the powers necessary for the management and the direction and supervision of the management of the company to the directors. So there's a high possibility that these powers may be misused by the directors. So in order to avoid that, there's a host of, or a list of directors' duties provided in the Companies Act. Out of this, our study is only focused on section 189 of the Companies Act, which provides for the standard of skill and care. if we look at the common law, the general principle is that directors are liable for damages which emanate from negligence in the performance of their duties, mainly because director has assumed the responsibility for the property or the affairs of the others when taking over the management of the company, which has been pointed out in Henderson versus Merit Syndicates Limited. When in terms of common law duty of skill and care, there's a very important and well-known case that is Rare City Equitable Fire Insurance Company Limited. The decision is made by Roma J. He says he adopts a very subjective approach to the director's duty of skill and care. He says in his own words, in discharging the duties, the director must act honestly and must exercise such degree of skill and diligence as would amount to the reasonable care which an ordinary man might be expected to take in the circumstances on his own behalf, which means that he is actually adopting and giving the benefit of doubt to the director. So the director here is only expected to show the skill, experience and the knowledge that he has, which means it's a very subjective approach. However, this approach has been changed over the time drastically, and today in the common law what we find is a very objective standard. Now this approach is mentioned in the case Norman versus Theodore Goddard, where the court says that the degree of care when it comes to a director in a company is not limited to the subjective approach but extend where it says it should extend to the general knowledge, skill and experience that a person should show as a person holding that particular function. Right? And also, he should also show general skills and knowledge of his own, which means there's an objective component and also a subjective component in this test that is adopted in duty of skill and care today. So I would like to call this a dual approach or a hybrid approach. A company director per se is not treated as an expert in financial management or in providing legal services. However, if a director has been appointed because he has a professional qualification, then that director should show what the skills and the knowledge and the experience that is expected of a person holding a similar professional qualification. The board of directors, if you take as a whole, is responsible for the decision taken by that board. In the case of Reliance Allotment Company, it has been stated that there can be no distinction between executive directors and non-executive directors. So what it means is, if you take a decision as a board, if there is any damage or harm that is caused to the company, you are jointly and severally liable. Now let me move on to the other jurisdictions which have similar provisions to Sri Lanka. I will first take Australia. In Australia, Section 180 of the Corporations Act of 2001 provides that a director or the officer of a corporation must exercise their powers and discharge their duties with the degree of care and diligence that a reasonable person would exercise. So this is a similar provision to Sri Lanka. Let's see how it has been interpreted in the judicial decisions of Australia. Now, when it comes to duties of directors, you can find remarkable judgments by Australian courts. Looking at these three cases, Daniels versus Anderson, Asic versus Adler, and Asic versus Healy, I would like to point out mainly 4 points. These 4 points are regarding the nature of the duty, ability of directors to delegate the duty of care, and the need of the director to be kept informed about the company's decisions, and also the fact that there is no difference between executive and non-executive directors. When it comes to the nature of the duty, all three of these decisions say that the nature of the duty must be both objective and subjective, which means again a dual approach. Then, when it comes to decision making of directors, they must always be informed. They must make an informed decision. And then, in even delegating the duty of care, in even delegating the information and all that, they have to show a standard of care. They can't simply say, we have delegated this task, so we are not liable. And of course, most importantly, all these cases highlight the fact that you may be a non-executive director or an independent director, still you are not absolved from the liability if there is a breach of the duty. So in summary here, as an analysis, I would like to say that Sri Lanka can adopt a similar approach. Right. Let's look at UK next. Now UK, as you already know, has a numerous set of laws for corporate law. Now, even though they had a long list of statutes for corporate law, the Companies Act of 2006 is the first statute to introduce the written or statutory list of duties of director. In section 174 of the Companies Act of 2006 of UK provides a director of a company must exercise reasonable care, skill and diligence, which has been described in the statute to be the general knowledge, skill and experience that may be reasonably expected of a person carrying out the functions, and also the general knowledge, skill and experience that the director has. This actually is a codification of the judicial decision in Theodore versus Goddard, which suggests that this is imposing a dual duty on the directors when it comes to duties of directors in duty of directors in standard of care. If you look at both Australia and UK, what you will see is judges in both these countries are very reluctant to review the decisions made by directors in a company. Their view is that what is in the best interest of the company should be decided by directors of the company. So they are not willing to second guess the decisions made by the directors in a company. So they will only intervene if they feel that no reasonable person would have achieved such a decision. This is actually what we term as the business judgment rule that we find and originated in the United States as a common law rule. The rule applies to the process of decision making by directors and actually consists of the rebuttable presumption that when the directors in a company make a decision, they make it in good faith, on informed basis, and also in the best interest of the company. So the aim of the rule is to protect the innocent directors who will otherwise take the personal liability. Coming to my recommendations and conclusions, first of all, I would like to say that in terms of directors' duty of skill, care and diligence, Sri Lanka must appreciate the complexities involved in the development witnessed by Australia and UK when it comes to that duty. In the terms of interpretation of the statutory provision, of course, we must pay attention to Australian provision and UK provision, which have similar wording and which has already been interpreted in their judiciary. So, in looking at the interpretation, we can always focus on the 4 factors that I highlighted earlier, that the duty must be a dual approach, which means there should be a subjective test and also an objective test. And also, even in the delegation, the directors cannot absolve from the liability. And the fact that there can be no distinction between executive directors and non-executive directors when it comes to the statutory duty under standard of care. I would like to suggest that when it comes to directors' duties, there must be an essential balance between corporate governance and overly intrusive laws. Okay? So this is my personal opinion, when making a suggestion for the development of the law, I think we need to consider the fact that Sri Lanka is a developing country. If we look at the Companies Act, there is a statutory duty for standard of skill and care. But the Act is very light on the protection afforded to the directors when it comes to this duty. But if you look at countries like Australia and UK, which are already developed, still they try to protect the directors' interest by using the business judgment rule in the interpretation of this duty. So if we do not introduce or if we do not define, interpret our statutory provision also in the backdrop of the business judgment rule, the directors there will be very adverse effects in the directors taking any risk or taking very innovative steps. So I would say that in defining and interpreting the director's duty of skill and care, we need to protect the interest of the shareholders, true. But on the other hand, we need to also consider the promotion of entrepreneurial endeavors on the other hand as well. So then only Sri Lanka will be able to boost the corporate financial success in Sri Lanka. Finally, I would like to say that director's duties is not a lawyer's law, it's a codification which was introduced with the aim of making it known about the public at large and the business community in particular, which means every stakeholder in a company must be aware of the director's duties as well as the protection afforded to directors. So these are the references I have made in this paper. Thank you.
Thank you very much, Ms. Sajeevi. And in her presentation, she elaborated the duty of care of the directors and also emphasized on the fact that there are no longer a category of directors called the sleeping directors. We used to have a set of directors in our boards who used to call themselves sleeping directors, but with the new companies that are coming into operation, there is nothing called sleeping directors or relaxing directors. Once you are a director, you have to make all your judgments well informed, good faith, and to the benefit of the company. So you cannot relax. And so therefore, she did a very good comparative analysis between Australia, UK, and Sri Lanka. And with that, I will close my observations and I will open the floor for questions from the presenters.